People v. Sherlock.
Good morning. May it please the court, my name is Lisa Marcosia from the Legal Aid Society of Suffolk County, and I represent Mr. Daniel Sherlock. I'm requesting 3 minutes for rebuttal argument.
Yes, of course.
Here, the SORA court incorrectly designated Mr. Sherlock as a sexually violent offender based upon New York's Corrections Law 168A3B, otherwise known as the Foreign Registration Clause. There are a few reasons why Mr. Sherlock's designation is an error. The first reason is based upon the plain language of the statute. The Foreign Registration Clause states that a sexually violent offense includes a felony conviction from another jurisdiction where the person needs to register as a sex offender in that jurisdiction.
So what are we missing?
So what we're missing here is that Mr. Sherlock was convicted under federal law 18 U.S.C. 2252. There is no federal sex offender registry. I know that people try to categorize SORNA as a registry, but it's not a registry. SORNA was designed to create uniformity amongst the various state registries and close any loopholes or gaps in registration.
Counsel, under your reading of this statute, could a person convicted of a federal offense ever be a sexually violent offender?
Under the essential elements test, I believe would capture it there. However, this is not under the essential elements under the Foreign Registration Clause, and it's my position that his conviction doesn't fit the elements.
Well, what about if his federal conviction had been in New Jersey?
No. So again, it's still a federal conviction, right?
Right, but wouldn't he have had to register in New Jersey then, or no?
So he'd have to register, he'd have to register in New Jersey, but
And then that wouldn't then trigger 168 here?
No, so the way that the statute reads is that they have to register in the jurisdiction in which the conviction occurred, right? This is a federal offense, and there's no federal registry. And if you look at SORNA,
But if the conviction occurs in New Jersey, right, it's a federal court in New Jersey, why isn't that conviction occurs?
Well, because it's
Why
not.
isn't that good enough?
Because when you look at SORNA, right, SORNA requires someone to register in the jurisdiction in which they live, work, or go to school. They define jurisdiction as a state, right? And so.
But in the chief's hypothetical, you have a federal conviction in New Jersey, and then they register in New Jersey because that's the place where they live or work or whatever the third thing was. So now you're registered in a foreign jurisdiction, are you not?
You're registering but that's, the conviction is coming out of federal court, right?
I understand, but you're still, I think the point that you're hearing is that New Jersey is itself a jurisdiction, and you are registered there, so if you move to New York, why aren't you subject to the foreign registration requirement?
Well, because I think it would sort of render this provision sort of meaningless, right? Because if you're coming to New York and you have a sex offense, you're going to have to register with the state regardless, right? So I think the purpose of this provision is to capture outside offenses.
No, maybe you're right here, but the question is, using the same hypothetical about our neighbor, New Jersey, and it's a federal prosecution, but it occurs in a federal court in New Jersey. Why isn't that the conviction occurred, the jurisdiction in which the conviction occurred?
Again, I think that
The first
it goes,
reference to jurisdiction is the one that you're tying to the second jurisdiction? Is that-
right, exactly, right? So, you know, the way that jurisdiction was interpreted with respect to the conviction being a foreign conviction, they consider the jurisdiction of federal, it being a federal offense as the jurisdiction, right?
Is that what the Foreign Registration Clause says? Does it have to be the jurisdiction in which the conviction occurred?
Yes, that's what it says. It says in the jurisdiction in which the conviction occurred, and I could pull up the language exactly.
I have it. I'll look. You answered Judge Halligan's question.
It's not a general, where the person just has to register more generally. It says in which the conviction occurred, and I think that's important.
Well,
and
it says in any other jurisdiction, right?
Right.
For which the offender is required to register as a sex offender in the jurisdiction in which the conviction occurred. You've got any other jurisdiction, and then at the end, jurisdiction in which the conviction occurred.
Right, and I think like if
It can't possibly be read at all as
I don't think you can.
potentially two separate jurisdictions?
That's not how I would read the statute. In People v. Knox, this court didn't read the statute that way. In that case, the defendant was convicted under Uniform Military Code, and this court found since there was no naval registry, there was no registry for him to register with. And so, I mean, there they were talking about him being designated as a sex offender
So
more
wait, if the conviction had occurred a federal conviction in New Jersey, I thought, well, would he have had to register in New Jersey?
I'm assuming, I mean, I don't know New Jersey's laws very well. I'm assuming they're similar to New York in that, or I guess SORNA would require him to register
Right,
in
but
New
doesn't
Jersey.
SORNA require him to do that?
What was that?
Doesn't SORNA require him to do that?
Right, but the way that it does, but again, SORNA is directing the states to maintain registries, right?
But now he's on the New Jersey registry.
Right, just like Mr. Sherlock's on a New York registry.
Right.
But again, when you're saying a foreign conviction from another jurisdiction, right? I don't think it could be, okay, the conviction, when we say that, we're talking about federal court. But then when we get to the second part, we're talking about a different jurisdiction, right? We're talking about the jurisdiction, you know, where he's now living or where the conviction occurred if you were to use New Jersey. I just don't think the statute can be interpreted to have two different meanings using the same word.
But it seems like it does under your reading, if I'm understanding. I take it that jurisdiction for you with respect to a federal offense is not a geographic location, but a court, right?
Correct.
Federal versus state, right? But when you have, and perhaps this is the part of it that the chief is looking at, I don't know, but he's required to register as a sex offender in the jurisdiction in which the conviction occurred. So if he's required to register in New Jersey, that's a geographic location, not a court system. So doesn't it actually have two different meanings? One, is it federal or state? In other words, what jurisdiction, what part of the court system? And the second, if he's required to register in New Jersey, that's a geographic jurisdiction.
So, I mean, it doesn't say in any jurisdiction, right? It says in the jurisdiction in which the conviction occurred. And I believe if you look at the case law, you know, that has analyzed the statute, it's always, okay, the person committed a crime in Michigan and they had to register in Michigan. You know, I think that if you look at, for example, the case in People v. McGee, that was a military crime that was out of the second department. They said, well, now there's a uniform military registry, right? So he committed a crime in the military, and he had to register with the military, right? So if you look at the case law, the way that jurisdiction has been interpreted has been, you know, where the court where the crime occurred, and not two different places. And I believe, you know, if you look at the people's brief, they argue that SORNA is a registry, right? They don't argue that, oh no, New York counts as the registry for that second provision of the Foreign Registration Clause. They argue that SORNA is effectively a registry.
So implicitly, they accept your argument. That's what you're saying?
Yes, Your Honor.
Can I just ask you to give us a working definition of jurisdiction that we can apply in this case in a way that makes sense and is consistent?
So,
What is a jurisdiction?
so a jurisdiction in this sense, I would say would be the court where the conviction came out of.
But the
So if it's
statute
a New
has
York,
a definition, right?
What was that? I'm
The
sorry?
statute has a definition of jurisdiction in it.
Which one, SORNA?
Yeah, section
Yeah, so
209110.
Right, so SORNA defines a jurisdiction as a state, right? It doesn't say the federal government, it says a state, and then
Right.
it has some other, you know, like some.
Right, state, territory,
right,
whatever,
exactly.
yep.
But it's a state, right? So, because again, SORNA doesn't have its own registry. It puts the obligation on the states to maintain a registry. So.
Well, that would seem to cut against your argument, wouldn't it? If a jurisdiction is a state and the states are the entities that maintain these registries, and you're arguing here that there is no analogous federal registry, then we should only be looking to states as jurisdictions, which makes the federal court, I would assume, not a jurisdiction.
But in that sense, I guess, then what would be the purpose of not to ask you, I'm just saying, I don't know what the
No,
purpose
please
of
don't ask me.
the Foreign Registration Clause would really, what are we trying to capture then? Because if you're convicted in federal court, you're living in a state, right?
Well, what about the example, I believe it was the chief that asked if the conviction occurred for a federal offense, but it was in the state of New Jersey.
Right.
Person had to register in New Jersey, and jurisdiction is a state, then that's a different state than New York.
You mean if he moved to New York
Correct.
from New Jersey?
After, yes.
Right, but then he's going to, right, but it would be the same analysis, right? I guess what I'm trying to say is that if he comes into New York and has to register after convicting the crime in New Jersey, they're trying to register him under the foreign registration clause, I think the analysis is
Right,
the same.
but I'm asking, if he'd already registered in New Jersey, stayed in New Jersey after the conviction for a period of time, registered there, when they come to New York, you can't use that, the
No,
foreign...
because SOAR is a New York statute, right? And so I believe that the person still has to qualify under the New York statute and satisfy the elements. And,
So would they have to register under a different provision?
well, they could have registered under the essential elements test, right, arguably, or and here we're talking about a designation, right? We're not talking about registration, right? So, I mean, arguably he could register as a sex offender but not be designated. I think that's an important difference. I'd also just like to note that the court, in this case, the lower court, when counsel at the SOAR hearing argued that this is not a foreign conviction, because it's not a conviction from another jurisdiction, it happened in New York, the court said no. The jurisdiction was federal court, so this is a foreign conviction.
So just to state the obvious, in this case, your client would register in New York under some other more normal provision as a sex offender. He just can't be designated a sexually violent offender.
So, right, our issue is with the sexually violent designation.
Would have to register under D, right?
Right, so A2D defines sex offense, and actually, that actually segues quickly to my next argument, is that 168A2D, which defines sex offense, specifically includes the federal child pornography conviction. And based upon that, it's my view that the legislator intended for a federal child pornography conviction to be a sex offense, but not a sexually violent offense. The amendments to the corrections law in 2002 amended the definitions for both sex offense and sexually violent offense and included penal law offenses for sexually violent and federal offenses for sex offense, including Mr. Sherlock's offense. Based upon those actions, I believe that it's clear that they did not intend for it to be a sexually violent offense.
Yeah, take another minute if you need it.
Yeah, I was going to just move on to my constitutional arguments quickly, if I may. I also believe that Mr. Sherlock's designation violates the equal protection due process clauses of the Constitution. The state is treating two groups of similarly situated people differently. Group one is a New York residents with non-New York registerable nonviolent sex offenses, and the second group are New York residents with New York registerable nonviolent sex offenses. Group one is being required to designate, and group two is not. The purpose of SORA is to protect the public. So if the government felt that you need the designation to protect the public, then group two would be required to designate as well, and it's not. And this, with respect to due process, it's the same argument in that there's no rational basis for requiring Mr. Sherlock to register as sexually violent simply because his nonviolent conviction occurred in another jurisdiction.
Thank you.
Thank you.
Good afternoon, Your Honors. My name is Lauren Tan, a parent of counsel to Mr. Raymond A. Tierney, District Attorney of Suffolk County. Your Honor, in this case, Mr. Sherlock's Level 2 sexually violent designation was proper in all respects. I'll address initially with the...
So actually, could we
yes.
start with one of the last points that was made, which is 168.2D, the registration provision, which, as your opposing counsel pointed out, has a specific subsection for this crime and a number of other federal crimes. In addition to the language about registering in another jurisdiction, it's almost a pattern of subsection 3B, but with the addition of specified federal crimes. And it seems to me it wouldn't make any sense for that to be the case if subsection Romanet 2 already covered those crimes. If you were required to register for child pornography, let's say, in New Jersey, but it's specific, and that would automatically get you the registration too, if it automatically gets you sexually violent predator designation. Why would they have to add those provisions of federal law?
Well, Your Honor, the 2002 amendments to that subdivision, it was in response to, there was some federal lawsuits, offenders, that had contested the equivalency of the federal and New York state statutes. So the legislature reacted based on those.
But if Romanet
Yes.
2 in that section, which reads a felony in any other jurisdiction for which the offender is required to register, the exact same language covers this crime in the section you want it to cover it in, why doesn't it cover it in this one, in 2D? So then why would you need the rest of it? Because you would capture the same amount, you would capture the same universe of crimes, right?
I'm sorry,
So in 2D,
Yes.
right, which is why you have to register in New York, it provides that you have to register if you have a conviction in a felony in any other jurisdiction for which the offender is required to register as a sex offender. The exact same language as 3B, right?
yes.
So if that covers this crime, which in your view it does in 3B, why wouldn't it cover it here? And so why would you need Romanet 3 that adds the specific federal provisions?
Of 160, I'm sorry, the 168A.
168A-D, 168A-2D,
Okay.
right?
So your question is why
Why
we
do
have
you
to
need
add-
Romanet 3 in 2D if Romanet 2 means what you say it means?
Well, that subdivision was enacted, I believe, in 1999. So the specific offenses came after in 2002, which.
But if your
Right.
view of why that was enacted is because it wouldn't pass the equivalency test, doesn't that go to your opposing counsel's argument that that's the only test for federal crimes? Because otherwise you wouldn't need it, because you would capture the same universe of federal offenses under Romanet 2.
Yes, but those challenges where the legislature in 2000 enacted those specific crimes, federal crimes, is a response to various lawsuits that came about with the federal offenders, and they were challenged under specific section of that corrections law. It wasn't challenged under the corrections law we have right now.
But if
So-
I might be missing something, but it says clearly in 168 2D, Romanet 3, if I have that right, any of the provisions of, and then it lists various statutes, and one of them is 18 U.S.C. 2252A, and I thought, maybe I'm mistaken, that the federal conviction here was under 2252A, is that right?
Yes, yes.
Okay.
So
And so why isn't the registration obligation governed by that provision, D Romanet 3, which expressly addresses that federal offense as opposed to covered under 3B?
Well, the 3B, if you're, you have to be you have to register as a sex offender in order to later on become
Yes.
conform to definition. So in this case, Mr. Sherlock was designated as sexually violent. It's based on the reading of the statute applies to the fact of his case.
He was registered as sexually violent under 3B, though.
Yes.
And I think the question you're getting is, why do you have to engage in that analysis when the very crime of conviction has been listed in subsection D, 168A2D, Romanet 3? It seems as if the question's been answered for you by the legislature. That's where they chose to put this specific crime, in 2D.
Well, I think it's a little bit different. The point, I think, is that's the registration statute, right?
Right.
But in the designation statute that we're debating here, they don't have those federal crimes
No, they-
listed.
they do
But they
not.
have the same language about registering in a foreign jurisdiction.
Yes.
So it seems a deliberate choice not to have those in the designation section when you had to put them in the registration section to have them covered, even though you have the same language you're now arguing covers those in the designation section, right? So if that was the case, why would they add them here? Why would they add the specific federal crimes if the language you say covers this crime is Romanet 2, a felony in any other jurisdiction for which the offender is required to register, et cetera? Why would they have to add Romanet 3 any provision of 18 U.S.C. 2251, et cetera, to this, and then they didn't add it to the other one.
Because the amendment in 2002 came out from lawsuits that specifically challenged the essential elements test.
Right,
Which
but
is
if,
what- right.
right, so to address that problem,
Of-
that this
of
may
whether they
not
should-
have been covered by the essential elements test, they had to add this. The answer wasn't it's already covered by Romanet 2. That should be your answer, not an amendment. It's not an essential elements question, it's covered by Romanet 2, because you had to register in a foreign jurisdiction here federally. But that wasn't the answer there. The answer was, okay, we'll add them.
I'm sorry, I'm not understanding the question as to what is it that, so the amendments that were added in 2002, they were in response to challenges under the essential elements test of whether or not the federal offender should be required to register under New York State SORA.
But I'm assuming that
But-
essential elements test is the same in the definition in 3B, because that has an essential elements test in it too, right?
Yes, it does.
So if they had to amend the first one on registration because the essential elements test arguably didn't cover it, it seems a concession that also Romanet 2 of 2D didn't cover it, which is a felony in any other jurisdiction for which the offender is required to register as a sex offender.
That foreign jurisdiction clause that designated Mr. Sherlock as sexually violent in this case, the fact that the legislature, are you asking that the legislature could have added that offense under, like,
I'm saying if they
included-
felt they needed to add it to 2D, which is essentially the same language as 3B, to cover these federal crimes, to capture them, why don't they also need to add it to 3B, which has the exact same language? The exact same language that you're saying captures those federal crimes. But in 2D, they felt the need to add the federal crimes specifically in order to fall within that provision.
because there were
So-
challenges regarding the essential element, whether or not the the federal crimes had the essential elements of New York crimes to render those.
But why do you need to get to essential elements? Your response to that litigation should have been, no, don't worry about it. We can just go to Romanet 2, which is it's a felony in another jurisdiction for which registration is required.
I understand, but that provision wasn't raised in those cases as challenges, so
But to the extent that
I don't know what would
the,
happen
to-
if they had raised it.
to the extent that the issue was that these crimes were maybe not meeting the essential elements test, and I think this is the same question asked a different way, the legislature chose to put it into 2D, but they have exactly the same essential elements test in 3B, and they didn't amend those crimes there. So if the legislature is essentially conceding through the amendment of the specifically enumerated federal crimes that the essential elements test is not making it, that it's not meeting the requirement, why, then it must fail on 3B because they didn't add those sections there.
I don't necessarily think that it fails because at that time when they added the amendments in response to litigation, like we have now, so I don't know if the legislature might later on add specific crimes.
Counsel,
So-
does it matter? I don't know that it does, I'm just asking you. In 2D, Romanet 3, which is the one that sets out the federal crime that's at issue here, 18 U.S.C. 2252A, that there is language after that regarding the elements of the crime? Does that matter for any reason?
For the
Do you know the language?
Yes, you talk about the specific felony designations?
Romanet
the
3
federal-
does not merely list the provisions, it then says, provided that the elements of such crime of conviction are substantially the same as those which are part of such offense as of the date on which the subparagraph takes effect. I'm just asking, does that matter for purposes of your argument or your analysis?
No, I think,
So it's superfluous, it was unnecessary to Romanet 3?
no, that language, the ending language was
Yes.
just to clarify that in the event if the statute themselves have changed later on in the future.
If the
whether
federal law
Yes,
changed,
the federal, I'm sorry,
yes.
the federal statutes change regarding to the numbering or just any language they want to make sure that the board of examiners or the courts can look back at the elements for the new crime to make sure they match with the old statute to fall under the sex offender.
They weren't
Is there-
capturing by title,
Yes.
they were capturing by elements.
Right.
Is there anything, so it seems to me that what I'm grappling with anyway is, why did the legislature feel it necessary to enumerate the federal offenses in the first provision, but not in the second provision, right? And so usually we read statutes so that there's nothing that is totally surplus, no meaning. Why exactly would they have felt it necessary to put it in the first provision, but not the second provision? I don't think I'm following you there.
First provision, it was being, the federal offenders were challenging the essential elements tests as pertain to their convictions, whether or not they should have to register in New York under SORA. But the challenges weren't.
But if the legislature thought, I mean, what we're looking at here is what does the legislature mean with any provision it enacts, right? So if the understanding was that the language which occurs in both provisions captured these offenses, why would they need to add this additional reference to the explicit, enumerate the federal offenses? Either it covers it seems to me, and it does so in both provisions, or it doesn't, in which case, it's a lot harder, I think, to make your argument. Excuse me.
Well, I mean, like I said, the 2002 amendments were a reaction to a variety of lawsuits that were challenged under a specific section of corrections law, not the one that we are dealing with right now. So if the challenge is being raised now, it may lead to some kind of action by the legislature, which is what we're arguing here, that whatever amendments that need to be done or any errors that the courts seem to have regarding this specific statute should be left to the legislature to remedy, which is what they had done in the 2002 amendments regarding to the essential elements test.
So, counsel, what's your best argument for why 3B applies here? Because you are arguing that 3B applies here.
Yes.
Is it an essential elements argument, or is it just the fact that it's a conviction of a felony in another jurisdiction?
No, it applies because he was convicted of a felony conviction from a federal court, which requires him to register under the National Registry pursuant to the SORNA. SORNA did not establish a public registry on a national level. It was already there. It just added
What was the federal registry that was already there?
the public national registry. It requires the sex offenders to, the states and other territories to input the sex offender information into a database that is national.
But isn't that then just a collection of registrations at the state and territorial level? As opposed to a freestanding registry?
Yes, yes. So the National Registry is a collection. It doesn't have its own federal, ability to get information from sex offenders. It does rely on the states and other territories.
That's not a notification system, that's basically for law enforcement, correct?
For which one? The national sex?
Yes, the national.
Well, there is a separate national sex offender registry that's for law enforcement, and there's the one that's public, for the public. So, but the states and various territories, they do have an obligation in SORNA to input the information up there to keep it updated. However, SORNA also provides not just baseline standards that all states have to incorporate into their sex offender registry. They also provides for obligation on the sex offender, the federal sex offenders, whether it's federal conviction or state conviction, to register under SORNA, and they are subject to federal prosecution if they failed. So it is a separate registry that it's.
Sorry, who's required to independently register under SORNA? I missed that. I'm sorry.
Sex offender, defendants who are convicted of sex offenses, whether it's federal law, military law, tribal law, or from the states.
Okay.
They have an independent duty to register under SORNA.
So they would not, well, they may register with the state, but you're saying they also send
Yes,
some
yes.
information to a federal official?
So, for example, Mr. Sherlock here,
Yes.
he has an obligation to register under our SORA statute because of the, our corrections law,
Yes.
and he also has to register under SORNA.
And
Which have their
who
own
would he
tier.
send that to?
I'm sorry?
Who would he send that information to? When he goes to register?
Yes, it would go through the local law enforcement agency wherever he resides or goes to school. or
Of New York
employs.
State? You're
New
not
York-
saying he's going to send this to a federal entity or
No, the
individ-
information does get
representative?
processed through the state and then enters into the national website.
So you're saying he's got to do 2 registrations? Is that what you're
He
saying?
has 2 different obligations to register, because SORNA itself has its own 3-tier system, and versus our SORA also have a 3-tier, but they're not exactly the same. And there is a federal,
Is it possible for a person to do one but not the other?
it is, yes, it is possible.
How would that be the case?
I mean, it is possible for a federal sex offender to have to register under a SORNA, but for some reason, the state doesn't require him to register under their own state's Sex Offender Registry Act.
So then when he registers, he's going to the state?
Yes,
And that state official would
Would
send it to
collect the information
SORNA?
and
Because
in-
they're not going to use it for their purpose, for the state's
Right,
purpose?
right.
Okay.
and they would have to input it into the national database and to fully comply with the SORNA. And if the federal sex offender fails to do that, they are subject to federal prosecution for failing to register and update information. So there are separate criminal penalties for failing to register under SORNA and the respective state SORA registration. So
But that individual you just described would, you're talking about an individual that commits a federal crime in the jurisdiction, right? But the state jurisdiction doesn't require registration. Is that what you're saying?
it can happen.
Okay.
I-
You have a jurisdiction you can point to where that might happen? As an example?
I don't have a specific case, but even, let's just say Mr. Sherlock, for example, under SORNA, I believe he would be, under their classification, he would be a Tier 1, so which is 15 years, I think, under the SORNA. His designation here renders him level 2, forget about the sexually violent, just level 2. Sexually designation, he would be registering for life. So it is possible that he would at some point be done with satisfying SORNA's registration, but he still had to comply with our state sex offender registration.
But because he's on the state registry, that would be reported, and it would still be on the SORNA registration, no? Am I misunderstanding?
Yes, our state's registry requires him for registration for life. At some point, once he's done with his SORNA obligations, and he still has to register under our state, the information will still be inputted into the national registry, but he won't be subject to federal prosecution, for example, if he fails to register and he has already completed his obligation to register under the federal statute. So he would be then subject to only state prosecution.
Thank you.
If there's nothing further, I'll just rely on our brief. Thanks.
Counsel, what's your argument for why SORNA is not a registry for the federal jurisdiction?
Right. So, I mean, I think you just have to look at the language of SORNA. SORNA defines sex offender registry as a registry of sex offenders and a notification program maintained by a jurisdiction. And then again, it defines jurisdiction as a state.
Is there an independent registration requirement for defendants convicted in federal court with SORNA?
They have an obligation to register, but again, it goes back to the state, right? So.
But is there a separate federal registration program?
No, so there's
when
no-
register?
There's no federal office that I know of that someone could go in with their paperwork and say, here I am, I'm registering.
So for example, when you change your address, which might trigger notification, right?
Right.
Do you have to submit that to the federal government separately, or just the state in which you are residing?
It's my understanding that it goes through the state, and these databases.
But not additionally and separately to the federal government?
As far as I know, it's all done through the state, and even these databases, they pull from the states, right? You're obligated to maintain updated information with the state.
So are you comfortable representing to this court that all of the registry information contained in SORNA comes from a state registry?
Yes, that is my understanding of it, and I believe if you go on the website, that the website discloses that as well. And
So your view is that the federal registry is a compilation
Right.
as opposed to a separate independently generated database?
Right. It's a database that's pulling its information from the individual states. And
Why couldn't it create a separate federal registry that just happens, as you say, to draw its information from the states? That sounds very efficient, as opposed to having someone else or some other entity specifically responsible for tracking those registrations.
right. So, I mean, I guess arguably it could, but the person convicted of a sex offense is not going to be going and providing that information to the federal government, right? It's going to go to the state where, the person's living,
Yeah,
right?
but that happens like under the human rights laws with the EEOC and local and state human rights organizations. You sometimes only need go to one because they send it to the other in accordance with the law. And no
Right.
one would say you didn't file a complaint with both.
Right, I understand, but again, there's not a separate registration process in federal court, right? There's no federal paperwork that someone fills out with respect to their registration, right? Again, it's maintained by the states, and that's what SORNA does. The SORNA is trying to make sure all the states require people with sex offenses to register, right? And there's this sort of uniformity amongst the states. And I would like to just quickly point out, I believe in Willman v. The Attorney General, that was a unique situation in which, and I don't remember all the specifics, but the Michigan was not requiring the person to register anymore, and under SORNA, he was. And SORNA sent him back to the state, right? You have to go register with your state, right? It wasn't, oh, we'll accept your registry instead, right? It was, you have to go back to Michigan.
Is it possible that the feds could treat a state registration as the equivalent for their purposes to a federal registration?
For purposes, you mean in terms of,
Yes, if SORNA actually is a federal registry.
so SORNA, but that's my argument, is that SORNA is not an
I
actual
understand.
registry. And so, that's why the obligation gets put back on the state and them to go register with their state. Thank you very much.
Thank you.